Let's return to that Constitutional Court decision today. A few moments ago, you heard the lawyer for Advocate Nomgcobo Jiba, Zola Mjavu. He was representing her in court after the Constitutional Court said it did not have the jurisdiction to hear the case. The organisation which brought this application to remove her from the role of advocate is the General Counsel of the Bar. The chairman of the GCB is Advocate Craig Watt-Pringle. Advocate Watt-Pringle, good evening to you. You lost in court today. It would seem that this is a loss for your organisation and what you were trying to do.
Good evening, Stephen. Well, yes, we did lose the case, although we succeeded in a small way in an appeal in relation to an issue relating to costs, which is quite an important matter from a principal point of view. But I think it's important to appreciate that we lost on the basis not that there was no prospect of success on the merits relating to the fitness and propriety of the two respondents to be on the role of advocates, but rather on the rather narrow basis that the court found that there was neither a constitutional issue in the matter nor a legal question of public importance which would warrant its involvement in such a matter.
Okay, you talk about the technicalities. I mean, originally you brought this application to stop advocates Jiba and Mrwebi from acting as advocates. They're now allowed to still practice. You're the chairman of the General Counsel of the Bar. Do you believe they're just not fit and proper for the position despite this judgment?
Well, the fact that we brought the application in the first place and succeeded in the High Court with two judges, and the fact that we opposed the appeal in the Supreme Court of Appeal with the limited success that we persuaded two of those judges of our point of view, but of course the other three went the other way, is obviously indicative of the fact that we believe that there were proper grounds. And it's unfortunate that with this rather substantial divergence of judicial opinion, that the Constitutional Court was not able to cut the Gordian knot and side with the one or other approach.
Why did you bring this application in the first place? This application that you've now lost, why did you decide to bring it?
Well, if you're referring to the application to have the respondents struck from the roll, that's the original application that we brought in the High Court. That was actually for two reasons. The one was we were requested by the National Prosecuting Authority to do so. We didn't, however, simply do their bidding. We carefully considered a number of judgments, no less than three in the case of Ms. Jiba, which courts had found her to be dishonest or less than candid in legal proceedings in which she was involved in her capacity as a senior NPA official, and in the case of Mr. Mrwebi, one such case. And so we found that there was merit in the complaints and we brought the application. As to the question why we went the further step of applying to the Constitutional Court, it was precisely because of this significant divergence of judicial opinion, where we felt that if there were that number of judges who thought that they were not fit and proper, that it warranted the attention of the highest court. And however, this is the result. It is, as I said, based on an approach to jurisdiction.
Are you not, I'm sorry, Advocate, are you not worried that you might have a little bit of egg on your face as the General Counsel of the Bar? As you said now, you brought this application basically because the former head of the NPA, Mrwebi Nkosana, asked you to, and it's well known the difficulties in the relationship between Advocate Jiba and Mr. Nkosana. Now you've lost. I mean,
actually, it wasn't Mr. Nkosana, and as I think I made clear a moment ago, we didn't simply do his bidding. We had to satisfy ourselves that there was a case. And you must the further point you need to bear in mind is this. These respondents were not members of any constituent bar, so we were not able to subject them to disciplinary inquiries, which is what we would have done with our own members. In that process, they would have had a hearing prior to any application to court. But because we had no disciplinary jurisdiction over these respondents, the first time that we really got to hear their version was after we'd put up ours. So we put up our case based on what not one, not two, but three and even 4 courts had found in relation to these respondents, particularly Ms. Jiba. We based our case on that. And then, of course, notwithstanding these final judgments in various courts in which Ms. Jiba was found to have lied and been dishonest with the court, and similarly with Mr. Mrwebi in one particular case, they were given the opportunity in the High Court to put up their response. That response, or those responses, were not accepted by the High Court, were not accepted by 2 of the SCA judges, but were accepted by the majority in the SCA. So I don't think it's really a case of having egg over one's face. The General Counsel of the Bar is duty-bound, or was under the law as it then was, to bring matters before the court where there was sufficient evidence to warrant a possible finding that an advocate is not a fit and proper person.
Advocate, thank
you. I'm not at all embarrassed that we did that.
Advocate, thank you very much indeed for your time on SABC News tonight. The Chairman of the General Counsel of the Bar, Advocate Craig Watt-Pringle.